Thanks, Senate Government Operations Committee, on February 18th, Thursday. And today we are going to look at what we hope is the final draft and potentially be able to mark it up and work on it, vote maybe, on the issue of juveniles and public records exemptions. So Tucker, do you want to just walk us through? And I see that Tyler is with us from DCF, but I don't see any of the other usual players. So I guess we'll wait and see when they appear. We did have this scheduled for 1:30, right, Gail?
Yeah.
Yeah.
I thought it was. I thought that's what it was.
That's what I thought too. So
Yes, Madam
we'll
Chair.
see. We'll
Like
see.
that tie, Tucker.
All right, we have people coming in right now. We have David Scher and Marshall Paul.
Oh, good. Okay. And those are two of the people we've heard from anyway by email, but great. Tucker, walk through the thing, but tell Senator Polina about your bow tie.
The bow tie was a commemorative, let's say, gift from some representatives who appreciated me during my clerkship many moons ago. I guess it's almost exactly 24 moons ago. So today I will walk you through the updates to your draft concerning public records and records related to the initial arrest and charge of persons under the age of 19. I will highlight each of the changes from the last draft and then do a high-level overview of the contents of the bill as a whole. And just while I was sitting here preparing for committee, I already have two technical corrections that we will have to update before the final version 2.1 is ready for you. So the first change that you will notice in section 1 is that the exemption has now been split off into its own individual subdivision, which will be 5B Romanet 2. The language in the first sentence is substantially the same as what you have seen in the past. It prohibits the disclosure of identifying information contained in a record reflecting the initial or arrest of the charge of a person under 19 years of age. Previously, it said of a juvenile. Based on the testimony you heard last week, this was changed to a years-based identification of the individual. And later on, I will highlight for you that there are two sections in this bill that will automatically replace that number with 20. So it will be 20 years of age, and that will take effect July 1st, 2022. The next sentence is entirely new. It states that a public agency may disclose identifying information relating to the initial arrest of a person under 19 in order to protect the health and safety of any person. This change was based on some requests from witnesses last week that specifically law enforcement agencies be able to publicize identifying information if there is a person who is at large and the public needs to know identifying information about that person. The next section under the new reader assistance heading labeled effective July 1st, 2022 will automatically update this exemption to apply to a person under 20 years of age when that age is raised in 2022. And this is the first place where we have a technical correction that needs to happen. The language in Romanet 2 doesn't match the previous section, and that was just a mix-up as we were proofreading. So that will be a quick fix later.
Can I just say, Gail, did you need to, you have your hand up.
Yes, we have a Kevin Gaffney in the waiting room. Is that a recognizable person?
Yes. Where is he?
Okay, I'm looking,
No,
I am
wait.
just looking him up and it looks like he's Deputy Commissioner of Financial Regulation. Okay, thank you.
Okay, oh, that's where, yeah, okay, great, thanks. Okay, sorry, Tucker. And Tucker, I will once again comment on your use of the term Romanet. I love it.
I enjoy
I always
being
say little-
precise, so.
Two little eyes, but Romanet is much better.
So section 3 is still in here. It is still optional. The committee has not yet made the policy decision about this, but to cover it from a high level again, all new Public Records Act exemptions or any exemption that is substantively amended after July 1st, 2019 will automatically be reviewed for repeal every 5 years. So if you don't want this to come up for review in 2026, and then when it is amended in 2022 to be raised to the age 20 in 2027, you will have to add in this language to state that this is not subject to the 5-year repeal review. And this is similar to what you do with reports, where you state that it is not subject to, I think it's 2 VSA section 20D, to set it aside so that we don't review it under an automatic sunset.
Okay.
Section 4, most of the text is the same as you reviewed last time concerning court custodianship of all records relating to a person under jurisdiction of the family court. That is in subdivision 2 at the bottom of page 4. There is a new subdivision 3 on page 5, starting on line 3. And this language mirrors what you have done for a person who is under jurisdiction of the family court, but it relates to a person who is under the jurisdiction of the criminal division of the Superior Court. The issue that was raised last time was that the bill as previously drafted would have this odd scenario where a case that is referred to criminal court would be public, identifying information would be public. But because it wasn't under jurisdiction of the family court, the public agency under this bill would still be withholding identifying information, despite the fact that all of the records would be public once it goes to criminal court. So to resolve this and to not further complicate the disclosure of identifying information by the public agency, this subdivision says no matter which court it's going to, criminal court or family court, the courts will be the custodian of these records as soon as it goes to either court, and they will be responsible for releasing the information. If it's referred to family court, the information likely will not be released, but the court is going to be the custodian. If it's referred to criminal court, likely going to be public, but the criminal division is going to be responsible for responding to the Public Records Act requests. So to cover all of the temporal timelines that we're dealing with here, a little bit redundant, initial arrest happens. It relates to a person under 19 or 20, depending on the year it happens. The public agency may release records, but shall not release identifying information within it, up to the point that the case or that a charge is filed and it is referred to a court. At that time, the public agency stops being the responding public agency, and the court becomes responsible for responding to the Public Records Act request. That's the cutoff. If there is an instance where there is an initial arrest, but no charge is filed and it is not referred to court, the public agency will remain the custodian of the records, but shall not release identifying information contained within the records. And if it would be helpful, I can write all of that out so that you can see who is responsible for responding to requests and when. The last new section here, the effective dates have been updated. The entire act except section 2 takes effect July 1st, 2021. Section 2 takes effect July 1st, 2022. And that is the date that the age in the exemption will be raised from 19 to 20.
Perfect. Committee, are there any clarifying questions? Senator Collmore?
Thank you, Madam Chair. I think I heard you say this, Tucker, but I'm not sure. I think you said if a case is referred to family court, the identifying information likely will not be revealed. You used that word likely. Is that because potentially there would be a situation where one of those exemptions would kick in terms of public safety, or did you mean something else?
I used likely in an evasive way to protect myself from covering the court rules about records, which, as you'll recall from earlier discussions, are different than the Public Records Act. From what I understand from cursory review and from earlier testimony in committee from Pat Gable, the courts recognize the Public Records Act exemptions that are built in and that are specific around confidentiality. But I wasn't entirely certain about that. So I said it is likely
Okay.
that information will be confidential.
Okay, thank you.
Senator Polina, I think you had a question, and then Senator Clarkson.
Yeah, actually, it was a similar question, not only about the family court, but you also said if it went to criminal court, it would likely be disclosed, the information. So I thought it's very likely it'd be disclosed if it's criminal. It's just not clear on which it is. Is it likely, really likely? Almost definitely?
I would agree with your assessment that it is very likely.
Okay.
Senator Clarkson, did you have a question? Oh, okay, I'm sorry. Any other clarifying questions about this? And we'll hear get the testimony on it from different people, but thank you, Tucker. That was a really good review for us. And I know that Tucker has to run up to or down to Senate Education, around the corner to Senate Education. So he will be back with us when he's done there, or when he's quadruple scheduled. So he may or may not be back, but thank you. All right. So that's here we have, and I have heard from Marshall and from David Scher both, but I would like them to just talk to the committee about the bill as it is right now, the draft that we have right now. So Marshall, do you want to?
Sure. Thank you very much, Senator. And I will be very brief. We support the bill as it is right now. I think it covers exactly the bases that had been discussed in the last two hearings on this issue. And as far as, if I can just provide a little clarity around the sort of the lack of definite certitude, or, as far as what will be released when, there are always exceptions. So in criminal court, there is a general rule that applies 99.9% of the time, that everything that happens in criminal court is part of the public record. But there are very rare exceptions to that that are handled on a case-by-case basis. That can be for things like, there's been cases where the government has been able to keep certain criminal court records confidential or sealed because releasing them to the public would release the name of a confidential informant. There's also sometimes that's done to protect sensitive witnesses or to protect witnesses that maybe haven't been disclosed in certain cases, but have been disclosed in others. And then in the juvenile court as well, there's a 99.9% of the time what takes place in the juvenile court is confidential. That confidentiality can be broken for various reasons. Again, like I said, 99.9% of the time it won't be. And when it is broken, it's done again on a case-by-case basis for very specific purposes, which can include, I've done it as a attorney representing a kid in a confidential court proceeding, but where it's been felt that some explanation of the outcome of the case would be valuable not only to the state, but also to the defendant. The defendant can waive that confidentiality. So we've certainly done that in cases where it's been important and beneficial to everybody to have that confidentiality waived. So I think it's fair to say with 99.9% certainty that the records in criminal court are public and the records in juvenile court are confidential. But in both cases, there are those rare exceptions to that general rule.
Thank you. Any questions for Marshall? Thank you, Marshall.
Thank you.
And thanks for your definition and explanation of youthful offender the other day. That was helpful. Thank you. David?
Thank you, Senator. For the record, David Chair with the Attorney General's office. I will also be brief. We support this bill as it is written. I think Attorney Anderson did a nice job of accounting for the various issues that have been brought up over the last couple of meetings, and we think this answers those issues and encompasses what we were hoping to see in the outcome. One other slight nuance I would add to the discussion is that it is important to remember that records can shift back and forth between, well, not back and forth, but they can be shifted. You know, a young person can be shifted from the jurisdiction of criminal court to juvenile court and vice versa if they meet, you know, given certain criteria around the offenses or around the age of the individual. And for that reason, I think it's another good policy outcome to have courts be the public records respondent. I think it eliminates a lot of confusion, gives one place that records requesters will go to, and the courts will know for certain where the youth is placed in terms of jurisdiction. So for all those reasons, I think this is nicely done and we support it.
Thank you. Thank you. Any questions for David? Okay. Let's hear from DFR. Did you want to weigh in again, Kevin? I know there you are. Michael Pichek was with us the other day, and I didn't know if you had anything further to add.
I don't have anything specific. For the record, Kevin Gaffney, Deputy Commissioner of Insurance at Department of Financial Regulation. Just a couple of points of, I think they've been clarified, but just further clarification. I know we've talked about motor vehicle convictions and DMV records, and I'm not going to assume, but I'm confirming that those records would still be accessible as they currently are, that any DMV convictions will find their way to DMV and be accessible by insurance carriers as they rely on that information for not only underwriting and accepting risks, but also for rating risks.
Once there's a conviction, yeah.
Yeah, once there's a conviction. So I think that's settled. The other record that I don't know if it was discussed previously is related to insurance, which is the accident reports that are done by either local law enforcement or whatever agencies at the scene. And certainly those records are, from a timeliness standpoint, even more critical. The DMV records, the adjudication process takes its course, and eventually, if there's a conviction, those find their way to the individual driver's record. An accident report is obviously something that's more timely, and someone may not be able to operate their vehicle. So the access to the accident reports is critical to the adjudication of claims and claim settlement. I think those would also, the accessibility of those would not change, but I don't want to assume that. I'm just raising that as, you know, now if something in the accident report is de-identified, it's still the facts of driver 1, driver 2 of the accident report will be available for claims adjudication. So those are the two areas that I just wanted to make sure that the bill wasn't intended to exempt from a public record.
Would those be after some kind of a conviction or immediately upon the accident?
Yeah, those are relatively immediate because, you know, you think about it, if you're sometimes accidents aren't clear in terms of fault, but sometimes they can be, you know, if you're rear-ended sitting at a stop sign, and you would certainly want to access that report as the person that was rear-ended to, you know, usually you have the information of the other insurance company, so you can actually file a claim as a claimant against that other carrier.
I might be wrong here, and maybe David can correct me, but my understanding is that unless there's a charge of something like negligence or something like that, that the accident is, I don't know. David, can you help us out with that? I'm thinking that it doesn't cover them, but
Right. If I understand the question, and it's always possible I don't, but if I do, I believe the distinction here is that most of these traffic offenses, or I should say traffic offenses period, are civil violations. And we're talking about offenses that are either charged or the subject of a petition, but are the basis for which is some sort of criminal activity.
right.
Or something that meets the elements of an offense. So I believe all the things that you're talking about would not be encompassed by this change.
Does that is that helpful?
That provides clarity for us. We just wanted to be sure that our takeaway was that.
Okay. Okay, yes, Senator Collimore.
Thank you, Madam Chair. Actually, that muddies it up for me. I'm trying to think of an example. Two people get involved in an accident at a four-way stop. One of the operators is 17 years old. When law enforcement shows up, they take the information, they take the insurance information, they file a report. Is that report available to the media in terms of identifying who the operators were?
The way I look at this, and David helped me out here, is that there's been no charge. There's not an arrest.
No.
So that it would be public.
Okay.
Because they're not if they arrest the person because they were under the influence, or they arrest him because he was driving 190 miles an hour and caused the accident, then there's an arrest. And at that point, my understanding is then it would be not subject to public disclosure.
But if the local newspaper or radio or TV station was interested in reporting on the event itself, they would be able to say 16-year-old Jeanette White was involved in an accident with 48-year-old Brian Scher.
If there wasn't an arrest.
Okay.
Is that right? Kevin, David, Marshall?
I agree with your assessment, Senator.
I agree also. I mean, the way that I read this, and I think it's pretty clear from the language, this just deals with arrest records, and that's what it's dealing with. And so if there's not an arrest, which there isn't in the case of the vast majority of traffic related problems, then this has nothing to do with those cases.
Okay, thank you.
Okay, any more questions on that or for Kevin?
Well, I was distracted. Sorry, I was having trouble with my iPad, but those things, what we just talked about, the accident happening with the 16-year-old, that would become public though. Okay, I just wasn't sure I was hearing you right because I was dealing with my iPad problem.
Technology.
Yeah, really.
Yeah. Okay, so any more questions for Kevin or on that topic? I think we're clear on that.
Yeah, but I think it's pretty clear. Unless there's an arrest, this is not an issue.
Yeah.
Accident reports are public.
And speeding tickets and traffic violations are civil offenses, so they are public. All right. Tyler, thank you, Kevin.
Thank you. Bye now.
Kevin,
Tyler,
good
did
to
you
see you.
Same here.
Did you want to weigh in?
Sorry, Senator, were you asking me?
Yeah.
I just had a moment lapse on my computer here. Technology. Thank you so much. Good afternoon to the committee. Thank you for this invitation, I guess, last week, but also this week. For the record, Tyler Allen, DCF Family Services Division. I was asked to speak last week about this legislation's impact on licensing. And to this end, I shared the bill language, the prior bill language, previous to these revisions, with our residential and childcare licensing directors. I described the function, content, and intent of the bill as I best understood it. So DCF oversees licensing in a number of areas, including residential, foster care, after school, center-based, and family care homes. This licensure includes background check processes, which consider convictions, substantiations, and court findings, but also reviews family records known to the department. Like other testimony in the matter, DCF doesn't foresee any significant impact to licensing practices related to the passage of the bill. The practice of requesting records from a public agency without court jurisdiction isn't typical. And the likelihood that a pre-charge referral to a community justice center or court diversion program would be involving behaviors that would be barriers to licensure seem very small. But of course, DCF will continue to monitor the progress of the conversation, bring any illuminating concerns to the committee, should there be any.
Great. Thank you. Any questions for Tyler, DCF? Okay. So let's go to Sheriff Anderson. Did you want to weigh in at all? And specifically, does the section on with the addition of being able to release information if there's a public safety threat, does that meet your needs here? Is that sufficient?
Thank you, Madam Chair. For the record, Mark Anderson, Windham County Sheriff and Vermont Sheriff's Association. To be brief, like my predecessors, we support this bill as written. I'm trying to pull up the draft with regards to the public safety exemption because I have not seen it yet.
It should be on our committee page.
I just opened your committee page, so I'm there.
Okay.
I haven't read it yet, so I guess I'll remain silent on that until I can put some eyes on it. I do have one point of clarification based on a comment about tickets being public. The Vermont Civil Violation Complaint is a document that's designed by the Court Administrator's Office, and there's an indication, it's a checkbox that says a related criminal charge. Now, I think it would be appropriate that we redact the related criminal charge in the case of a juvenile case in which this exemption would apply. However, I would assume that a redaction would then imply that it was checked. So I guess I'm looking for clarity on how we are to handle referencing materials. I don't think it's by any means a game ender, just not sure how to deal with that.
So if you didn't make an arrest, but there's a box that you check that says there might be a related criminal charge. And if you check that, and then when you release the traffic information, the accident information, whatever it was, and that's redacted, the assumption is that it's been checked because maybe it should be redacted on every, I don't know.
And that could be a reasonable solution, is that we just always redact that field. I'm not sure if others might have a suggestion. Just wanted to make it a point of consideration. It's something that agencies, I think, will need to have in place depending on how this is enacted. But thank you.
So, thank you. Marshall or David, do you have any suggestion about how to do that?
Sure. I would just say that, I mean, that's a good thought. I hadn't thought of that issue. And now that Sheriff Anderson mentions it, of course, there is that box on the civil violation form. I think that form is prepared by the courts. And so perhaps the way to handle that would just be to direct the judiciary to make their form compliant with this
Oh,
new law.
is that me that
Must be
went
on
away?
or anything. Oh, excuse me. Can you hear me?
I
Yeah,
think
you
you
just-
froze for a moment, but it might have been me.
Oh,
No.
okay. Yeah, I just got a pop-up that says my internet connection is unstable. So
Okay,
that's the danger of trying to do this from home. But so I think that it might be something where the judiciary can just revise their form to make it compliant, or where the form could simply be redacted in every case. So I think it might be something where there's a procedural rather than legislative fix.
good. I like those. David?
I agree with that proposal. I don't think there's any need to try to deal with this in legislation. I think we can figure this out administratively.
Good.
And I am
So-
fine with those answers, Madam Chair, and having reviewed the public safety announcement exemption or portion of the under subsection 2, I'm comfortable with that language.
Okay. Anybody else have questions for Mark? Okay. So I see we have Mike here. I don't see, is Lisa with us? I don't see Lisa, but Mike, would you like to weigh in
Madam
on
Chair,
this?
Thanks. She got called away at the last minute,
Okay,
and just the only point she was going to make, and again, it's Mike Donahue from the Vermont Press Association. I was trying to stay away from this because I've covered this story of Isabel
Right.
Seward, but I'm sort of, we're a small group, so I guess it's been punted back to me for just today. I think Lisa was going to essentially say the Press Association supports the status quo, much like the governor's office in DPS, and the tickets and citations continue to be public record, that there was just a small tweak that might be needed. It does seem there was some concern that the judiciary is going to control records of a separate branch of government, which is a little odd that the executive branch or legislative branch don't get to control their own records. I'm sure, I wonder if there would be an uprising if the governor's office suddenly said they were going to control the legislative records, but I'll leave that debate for another day. I think we are happy that there is some possible relief. I think Senator Collmore brought it up a couple of meetings ago, sessions ago, hearings ago, about, you know, the guy that was involved in the shooting over at the University Mall, part of the Riverside gang that was in a shootout with another gang over there. They had 5 shots fired, and they've obviously put names out of at least one person that they want. So, I mean, I think it's critical that the police be able to turn to the public and say, we're looking for this person or that person. I mean, we just got a press release just in the last hour of 3 juveniles that are missing up in the Northeast Kingdom from a bunch of towns. Sorry, my apologies here. I forgot to shut my phone off. So obviously that becomes an issue for a lot of the police departments, state police and local police, to be able to get words out that there are suddenly these 3 teens from Hardwick, Martin, and Danville, I think it was, that are all suddenly missing up there. But all in all, we were glad to hear that the motor vehicle accidents will be fully available, that the traffic tickets, like the governor's legal counsel mentioned, since those are civil violations, that remains unchanged. So I think we do have some concerns that, again, somebody could kill somebody on the highway in Vermont. And as the editorial in the Times-Argus Rutland Herald said, it's $110 a body, and the person conceivably would never be identified. And I think that's troubling to a lot of people.
Thank you. I know your concern about, and Senator Collmore did bring it up, and I think that there was language put in here in response to his concern about the issue of public safety and being able to put someone's name out there if you know who you're looking for, and that person is a threat to public safety. So that language has been put in here, and I believe that would also cover the issue of the 3 missing teenagers, because it says for the safety, I don't have it right in front of me, but it is meant to cover those issues that either is a threat to public safety or the safety of the missing person or Senator Collmore, did you?
Yeah, I agree with you, Madam Chair, and Tucker's back with us. So I think the issue there is that the bill is silent on the safety of someone who's missing. Like, we have a skier down here in Rutland on occasion that'll, go off the path and get lost, and they can put the name of that person out because there's been no arrest, there's been no violation of law. It's just they're looking for him or her to try to find him. So I think, to Mike Donohue's point, the bill doesn't need to address that because there's been no arrest.
And in the case of the person that they're actually looking for, that they plan to arrest, there hasn't been an arrest yet either, but the language is in there to allow that person's name to be public. Is that true, Tucker?
Yes, the language is in there to cover what seems like a rare instance where there is an initial arrest, but the person is at large. And you would have to ask Commissioner Sherling about those situations, but he did say that there are instances where there is an arrest, but the person is not yet apprehended or in the custody of the public agency.
So, I think yes, Mike.
Well, okay, I'm now totally confused because, and the sheriff, maybe if he's still on, I mean, there is no arrest really until a person is in custody, and basically, so I'm not sure what Tucker was saying there, because there may be an arrest warrant, maybe, but there is no arrest. So,
well, Tucker or Sheriff Anderson, do you want to respond to that?
Remember that the language of the subdivision states that records relating to the initial arrest of a person are exempt here, right? Persons under the age of 19. And there was testimony from law enforcement officials that there are instances where there are records relating to the initial arrest of a person that are created prior to that person being arrested. That is the understanding that I had from last week's testimony, and the reason that the ask was submitted for that clause allowing identifying information to be released from initial arrest or charge records in the event that that release is necessary to protect the health and safety of any person.
Senator Collmore?
Yeah, I think one example that we heard from, I don't know whether it was Sheriff Anderson or Commissioner Sherling, someone could have been arrested and taken into custody and then escaped. And that would allow the law enforcement community to put that name out there, because at that point, he or she is potentially threatening public safety. So you're correct, Mike, as far as it went, but there could be an example where someone's taken into custody, arrested, and then escapes, and that this would still allow that identity to be made known.
And I'm going to throw in another thought, and I think it covers this also because it relates to the initial arrest records. So if they know who's standing there at University Mall and is parked whatever it was that happened at University Mall. They know who it is. They're going to issue an arrest warrant. So there hasn't been an arrest yet, but there is a warrant out for the person, I would think. And this covers that situation also, where there hasn't actually been an arrest, but they're looking for a particular person. Am I right about that? Tucker, Sheriff Anderson, Marshall. Everybody's on mute.
I mean, I think you're pretty clearly correct about that, because that, you know, it is a record that relates to an arrest, but there is a public safety issue.
Right.
So while it falls within section 1, you know, the public safety issue makes it so that it is exempt from the prohibition and can be made public. And it's, just to be clear, it was me who said that I'm aware of cases where I've had clients who have been arrested and then escaped, and there's been a need to find them. And that's, you know, I would say it's not even necessarily, you know, certainly if someone has been arrested, then this law might apply to them. But then, of course, the public safety exception would allow disclosure for public safety, or, and this is the point I wanted to make, was sometimes it's not public safety, sometimes it's for the safety of the kid. In fact, I would say most of the time when I've had clients who have escaped, there's been a lot of worry. It hasn't actually been worry for the safety of the public, because most of our clients are really not threats to the public. But there's often worry about the safety to that kid. And that was part of what I was really happy to see in this bill, was that it allowed disclosure, not just for public safety, but for to protect the safety of any person, which would include the kid themselves.
Good. Yeah, I think that you are right about that. Senator Clarkson?
Yes, I'm just concerned by the word, the warrant, the search warrant.
Not search warrant. I didn't say search warrant.
No, but to go back to what I thought I heard Mike say, and I think Mark, I mean, when you're searching for someone, you have to put out a search warrant, right?
No, that's not a search warrant.
Okay, it's just that, okay, because that was my concern, is with a search warrant, don't you have to identify a reason for that? And is that might be awkward.
That's not a search warrant.
Okay, what is it called?
Arrest
I think
warrant.
it's an arrest warrant. You're looking for them to arrest somebody. It's an arrest warrant, not a search warrant.
Okay.
There's a difference between searching for somebody and searching a house or a car. That's a search warrant.
Okay, I'm sorry, I'm confused. So we're exempting the arrest warrant?
No. Oh, if here's,
I thought, I mean, if it's called an arrest warrant, I have a concern, because anyway, I guess
if it's in the public safety, if they know who the person is,
right,
and the person presents a risk to either themselves or to somebody else or to the public,
right,
then they have the ability to disclose the name.
Right. Okay. Got it. Thank you. But it's called an arrest warrant. Yeah, that's disturbing, but yeah.
Well, that's what it is. It puts out a warrant for your arrest.
Yeah.
So anyway,
just to add a point of that might be more confusing than clarifying, but in the juvenile world, we don't usually have arrest warrants. We usually have juvenile pickup orders.
Okay.
They essentially are the same thing, but a little different.
I think that the less technical jargon we use in this instance, the better off we are, just knowing what it is we're trying to do here. We're trying to keep arrest records of juveniles confidential, because they might end up going to family court where they're confidential, and then that confidentiality is a little bit irrelevant since it's already been made public. But we are exempting from this prohibition of the release of information anything that would the name of anybody who would either where they're looking for someone who would either pose a risk to themselves or to others. And that in that case, those names could be those names or an identifying characteristics. It may not be their name. It may be the identifying characteristic. It's a blonde 16-year-old woman from Putney. We're not sure what her name is, but it's identifying characteristics. Okay. Are we clear about this now? Yes, Mike.
I just want to, Senator Clarkson, just to be clear, a judge does in fact sign an arrest warrant. It's just not handled by anybody, but the police have to go and get an arrest warrant from a judge usually for an adult pickup. And I just want to be clear on one thing. So in the situation with the Riverside gang at the University Mall, the person who's wanted primarily there is 18. It's an adult arrest warrant. But just to be clear, the state's attorney can later decide that they want that case to go to family court, but the name is still was out there at some point.
But in that case, it would fall under the exemption for the public safety.
Right.
Yeah. But I just wanted to make clear that you may have a situation where it's public at one point and then suddenly it becomes confidential, but everybody knows who it was.
Right. Well, I think Marshall was right in his assessment that 99.9% is about as close as we can get to anything.
But I thought it would be clear, Madam Chair, that anyone who was 18 was still considered a juvenile, no matter where you were in the pickup process. That until you were convicted, if no matter what happened, other than the search thing, other than the search warrant, the anything that happened, other than a civil offense, if anything else, 19 or under was considered a juvenile. So Mike's example, the 18-year-old shouldn't happen.
Unless the proactive disclosure is necessary to protect the health and safety of any person.
Yes.
And in the case that Mr. Donahue highlighted, the public agency would be permitted to release that information in order to protect the safety of a person and would do so, but later may not be permitted to release that information in a record reflecting the initial arrest, which was Mr. Donahue's point. You may have redactions later, despite the fact that the identifying information has already been released and the public is aware of who the person is.
Right. Imperfect, but there we are. Right.
Well, our systems are all somewhat imperfect,
right.
And it is impossible to craft laws that cover every situation. But I think that the intent here our move is to in justice reinvestment and justice reform is to for the protection of people so that their lives aren't ruined. And I understand that there is public interest in lots of stuff, but we need to be able to weigh the individual rights with the public's right to know. And sometimes the public's right to know is, I hate to say this, but just because they want to know, it doesn't serve any purpose necessarily. People just would like to know who that kid was that was arrested. But anyway, so anything else that anybody would like to say here, or are we at a point where we feel comfortable with this? Senator Clarkson?
Yes, that was up.
Oh, okay. I couldn't tell.
I'm fine.
Keisha?
Yep, I think we're good to go.
Senator Polina?
Yep.
So can we make this a committee bill?
I thought it was.
Well, it isn't anything yet.
Oh, it's still just draft number, right?
I'm
Yes,
still
let's,
planning on voting no on this, Madam Chair.
So then I think we won't make it a committee bill. I mean, it can't be a committee bill unless we all agree.
Right.
So,
so
Tucker,
let's make,
yes,
so then we're gonna make it a bill of Clarkson, Rom, Paulina White.
if that's what, if everybody wants to be on there except Senator Collmore, that's what I would suggest.
Great.
Okay. All right. So Tucker, can we do that? And I don't.
Yes, I will get that started.
Okay, and then, so it can, this doesn't have to go to any other committee. It won't have to go to appropriations or finance or anyplace else. And I've been keeping judiciary involved in the conversations. So even though they're not really involved in law enforcement. Okay. Thank you. Thank you. All right. So can we move on to our municipal pilot? Bill? And is that you again, Tucker?
It is. Are you all tired of seeing me yet?
Wait, Mike, did you have a question or were you waving goodbye? You're muted, so I can't tell what you're saying, but I think you're
Oh.
waving goodbye.
I'm waving goodbye. Thank you for your time on this and everything else.
Thank
Thanks,
you.
Mike.
Thanks, everyone. Yep.
And I see Gail has her hand up.
Yes, Madam Chair, Karen Horn and Gwen Zakov will be joining us at 2:30.
Oh, I thought it was 2:30. Okay.
We're close. We've got about 6 minutes.
Oh, okay. Well, I think we can start walking through it.
Okay.
Thanks. All right.
Shall I start, Madam Chair?
Yeah, can I, I was looking at before you start, I was looking at some stuff the other day. It was in our Title VII. I don't remember where it was, maybe in the Constitution. Anyway, it's interesting because the way the federal Constitution and the federal statutes work is that the states can pass and can regulate anything that isn't prohibited by the federal government. So we like that as a state, but yet we impose the exact opposite on our own next level of government. I just thought I'd point that out.
Madam Chair, I took a class called Local Government Law at Harvard Law School when I was a grad student at the School of Government. And it's a class the teacher's been teaching for 40 years. And it's essentially about that topic and why that works. So if you ever want to borrow my book, it's a whole exploration of that topic.
No, I mean, isn't it Article 10 of the Constitution that
It is
says
the
that?
10th Amendment.
10th
Yes.
Amendment.
That
Mhm.
any powers not granted to the federal government are reserved to the states and the people. It is the only amendment that grants rights and powers to a unit of government and not to individuals specifically.
And yet we don't grant the same power to our next level of legislative bodies or government. So anyway, I just thought I'd point that out.
This is one of her favorite subjects, Keisha, in case you hadn't noticed.
Well, I've taken that class. Barack Obama's taken that class. Moreau Weinberg has taken that class. I highly recommend you go take that class. It's really
I've taken it from Frank Bryan.
nice. And I
And
took
many
the class as well.
many tutorials from him.
Yeah.
So, okay. Sorry about that. I just had to throw that in as always.
It's a good place to start.
Yeah, someday maybe we can have the summary, what did we call it? The little yellow books, the
Cliff Notes.
The cliff notes on the class would be very helpful. But given none of us, at least not at this point, are going to the Kennedy School.
All right, Tucker.
Well, the supremacy of laws is a great place to start, and it does play a role in this bill. And an important thing to note about the way that the Dillon's rule states operate in comparison to any other model of organization of local units of government is that the General Assembly in the state of Vermont can grant any specific power, delegate any specific legislative power that it sees fit to any municipality within the state, which is unique and potentially very powerful for units of local government if you grant them the power. The bill that you have in front of you is a rerun of S-106 as it came through this committee and was passed by the Senate last biennium. There is one clarifying edit that was made for purposes of the draft you have in front of you. It's highlighted in the document as it was posted, and I'll cover it when we get to that point. It's the only change made from the bill as it passed out of the Senate last biennium. The bill starts with a findings and intent section that describes findings of the General Assembly concerning the relationship between municipalities and the state. It begins by stating that the General Assembly finds that state law and policies at times inhibit or delay the ability of municipalities to adopt and implement solutions to local problems. That state law, policies, and procedures limit the ability of cities and towns to creatively work with the state in a timely and efficient manner. That municipalities lack the ability to make the best decisions to meet their truly local needs, and that establishing the pilot program authorizes a limited number of municipalities to engage in self-governance within defined parameters, and that will allow the state to determine gaps in municipal power. It will provide a laboratory for cities and towns to develop local solutions, and it will allow municipalities within the program to more efficiently respond to the needs of their residents. Moving on from the findings and intent, we'll get into the operative provisions of the bill. Section 5802 is added to define certain terms for use within this new chapter and to cover the general eligibility of applicants to the program. This section defines commission, municipality, program. Municipality is the one that you'll want to take a particular look at. The definition of municipality is limited to incorporated cities and towns. No other form of municipal corporation in the state would be eligible to participate in the program under this chapter. Proposal is defined here, and this limits some of the eligibility as a plan that describes the enumerated powers that the municipality requires for the adoption of ordinances that are not in conflict with the U.S. Constitution, the Vermont Constitution, federal laws, and the state laws that are listed in section 5805 sub C, which we will get to later. It's a long list, and that provide for the health, safety, and welfare of the population within the territorial limits of the municipality. This is another piece that gets repeated and hammered on over and over again in the bill. This is limited to the authority that the municipal corporation has within its territorial limits. And later, it's expressly stated that any of the ordinances or powers that are granted won't allow a program participant to affect any other municipality. Further, that the plan describes the measures a municipality expects to pursue, including the adoption of any ordinances. Section 5803 contains the procedure for adopting a proposal that will be submitted to the commission and later to the General Assembly. And this procedure is modeled after the charter amendment procedure that exists in Title 17. And I'll move through this somewhat quickly. If there are any particular questions about the process, happy to get into it. And I believe that this section was the first time in my career as a legislative counsel that I used the blackboard in the Senate Government Operations Room, because we mapped out how long it would take to adopt a proposal. So a municipality that is seeking to participate in the program is going to be required to submit their proposal to the voters and follow the following procedure. First, that an official copy of the proposal shall be filed with the clerk 10 days before the first public hearing. There are two. The legislative body shall hold at least 2 public hearings before the vote at an annual or special meeting. The first public hearing shall be held at least 20 days before the annual or special meeting. The legislative body has the authority to revise the proposal in light of recommendations made at a public hearing, but that no revisions may be made fewer than 10 days before the vote. The second public hearing shall be held not later than 10 days after the first public hearing, so you have 2 in somewhat rapid succession. After the warning and hearing requirements are satisfied, the proposal is submitted to the voters at an annual or special meeting in its certified form, and the legislative body has permission to make technical corrections prior to that point. Municipalities are permitted to amend an approved proposal after it's been approved by the voters by following the same process we just went through. It's the same as charter amendments. You still have to follow the charter amendment procedure. Upon approval by the voters, the legislative body shall submit the proposal or amendment to the commission. And that segues beautifully into section 5804, which creates the Municipal Self-Governance Commission. The commission is created and consists of 12 members who are appointed as follows. First, 4 members shall be appointed by the governor, not more than 2 of whom shall be from the same political party. 8 members will be appointed by the General Assembly, 4 by the Senate Committee on Committees, and 4 by the Speaker of the House. Of the members appointed by the Senate, not more than 1 may be a legislator, and not more than 2 may be from the same political party. And of the members appointed by the Speaker, not more than 1 may be a legislator, and not more than 2 may be from the same political party. The terms of members of the commission are 2 years. The commission shall have the power to review, evaluate, and make recommendations concerning a proposal submitted by a municipality. They'll have the authority to establish criteria for the evaluation of proposals, and that includes each municipality's population, geographic location, and governance structure. They will have authority to consult with state agencies that may be affected by the proposal, and to recommend to the General Assembly the municipalities that should be approved to participate in the program. Subsection E states that the Office of Legislative Counsel will provide administrative and legal assistance to the commission. The commission shall have its first meeting at the call of the Speaker of the House, and that shall occur on or before November 1st, 2021. The commission shall elect a chair from among its members. 8 of the 12 members are required to constitute a quorum of the commission. Subsection G covers the compensation and reimbursement of the members of the commission. G1 covers legislative members, and that per diem compensation is governed by 2 VSA section 406. All other members their compensation is governed by 32 VSA section 1010, which is the section that governs all other members of commissions that you've probably reviewed many, many times, especially if you were on the Boards and Commissions Review Committee. Payments will be made from monies appropriated to the General Assembly. Subsection H deals with required reports. So first, on or before January 15th, 2022, the commission shall submit a report recommending at least 1, but not more than 10 municipalities to participate in the program. And the commission is required to recommend municipalities that represent a range of populations, geographic locations, and governance structures. At any time after January 15th, 2022, The commission can submit subsequent reports recommending additional municipalities, but at no time during the existence of the program shall more than 10 municipalities be admitted to participate in the program. I will note that, of course, statute would not bind the General Assembly's authority to admit more than 10 municipalities if that's how the General Assembly decided to proceed. On or before January 15th, 2026, the Commission is required to conduct a performance review of the program and submit a report that contains evaluations of the effectiveness of expanded self-governance, a recommendation as to whether the program should be reduced, expanded, or terminated, and a recommendation as to whether additional legislation is necessary to modify the program, including any recommended additions to section 5805 sub C, which is the list of prohibited statutes that the proposals cannot touch, and any other relevant matters. Commencing on January 15th of the year 2023, and each year thereafter, the Commission is required to submit a report that contains all of the municipal progress reports, which we haven't gotten to yet, that are required by section 5805 of the chapter. So they'll be bundling all of these municipal progress reports and submitting them to the General Assembly. The Commission is required to hold program meetings with the attendance of representatives from each of the admitted municipalities participating in the program. Legislative bodies of each participating municipality are required to appoint a representative who attends these meetings. And that is all for that section 5804. Section 5805, this is the critical operative piece of the bill, and where last biennium there was the most tension and confusion about how the program operates. It's also the only place where there is a clarifying change or edit from what you reviewed last biennium. Subsection A states that, consistent with Chapter 2, Sections 6 and 69 of the Vermont Constitution, the General Assembly shall have the sole authority to approve proposals and any proposal amendments and admit municipalities for participation in the program. So the new language is the addition of shall have the sole authority. It is redundant. As it was written last year, it stated that the General Assembly shall approve proposals and proposal amendments. It was written to reserve all authority to admit the municipalities to adopt statute, which is an exclusive power of the General Assembly. But this was added to make certain that those who are reading the bill understand that the General Assembly has the final say in all of this. A municipality that is approved by the Assembly for participation in the program will have authority to adopt or amend ordinances pursuant to the powers that are granted to them. And now in subsection C, we get to the list that sets aside what a proposal may not touch. So subsection C states that a municipality's proposal shall not include the authority to adopt or amend an ordinance that is inconsistent or in conflict with the US or Vermont Constitution, federal law, the Public Records Act, the Open Meeting Law, what is colloquially described as the Sportsman's Bill of Rights. That's 10 VSA section 5227, 24 VSA section 2291 sub 8, and section 2295. And to refresh your recollection, those sections deal with the regulation of sport shooting ranges, and regulation of hunting, fishing, and trapping at the municipal level. There are prohibitions. I would recommend going into those statutes if you're curious about what is being restricted here. State law governing the following subject areas are also set aside from the proposals here. Firearms, the environment, conservation and development, forestry, or fish and wildlife, And in that sub B, those terms were specifically selected because they relate to entire titles of the Vermont statutes annotated that were lifted from the program. Crimes and criminal procedure, cannabis, state lottery and games of chance, alcoholic beverages, except that municipalities here may propose to increase local license fees, health insurance, banking, securities and insurance, electric utilities, workers' compensation, minimum wage benefits and employment protections, elections except for local elections, state highways, state sign law requirements of 10 VSA Chapter 21, standards for classifying town highways under 19 VSA Section 302. I know that well, I live on a Class 4 road. Procedures for laying out, discontinuing, and reclassifying town highways under 19 VSA Chapter 27. Motor vehicle requirements of Title 23, except for Chapter 19 of Title 23, which relates to parking, aviation, or railroads. All of those are pulled out and may not be contained in a proposal. Subsection D states that a municipality shall only have the power to adopt an ordinance or bylaw that applies within the territorial limits of the municipality. They cannot adopt an ordinance or exercise a power that would require or prohibit action by any other municipal corporation. And to help you understand some of the discussion that happened around this particular subsection, this was about whether municipalities would be given authority over school districts. School districts as an independent municipality called out here, the municipalities would not be able to exercise that authority. Commencing on October 1st, 2022, and each year thereafter, the participating municipalities shall submit progress reports to the commission. And if you recall, the commission will start bundling those annual progress reports and send them to House and Senate government operations. Those progress reports shall contain the following minimum requirements: a narrative description of how the authority granted to the municipality has been exercised and what the results have been, a list of the ordinances that have been adopted pursuant to an approved proposal, the estimated fiscal impact of any ordinance that has been adopted, and a summary of any pending or active suits, proceedings, or petitions that challenge those ordinances. And finally, any information that the commission may require for purposes of exercising their duties under this chapter. Section 5806 provides that the program shall terminate on July 1st, 2026. So it's only going to be in existence unless the General Assembly comes back and amends this for 5 years. Any ordinance that is adopted during that 5-year period that the program exists and is approving proposals will continue to be in full force and effect until it is either superseded or repealed. No ordinances may be enacted by a municipality after the termination of the program. The effective date is on passage.
Yay. So are there any technical questions for Tucker? I have a couple comments, but Senator Collmore and then Senator Clarkson.
Thank you, Madam Chair. I think I've figured out the answer since, but let's see. Page 5 is where the creation of the Self-Governance Commission is talked about. I'm assuming that since the Committee on Committees and the Speaker are responsible for 8 of the appointees, they have to be from the General Assembly. In other words, they could they appoint Joe Public?
They have to.
Yeah.
Okay.
Only one can be a legislator.
All right. And my second question, in the list of prohibited areas of government, education is not listed, but I think you sort of answered. In other words, if a municipality said to itself, hey, you know what? We think everybody that only goes to 10 grades should be able to be a graduate of high school. That wouldn't fly because the other municipality, the school district, comes under the Agency of Education jurisdiction, correct? And bless you, Madam Chair.
I'm actually not sure how the relationship would work. If the school district controls those educational requirements, which again, I'm not certain that if they do, then the municipality would not be granted any authority under this program to control the school district's area of authority. However, something that I brought up even when this exhaustive list was being put together, this list communicates to each of the municipalities applying to the program what the General Assembly does not want to see in a proposal, but it does not restrain the General Assembly from granting whatever authority they choose to give at a future date. So,
I mean, that was an extreme example, but you know, a town or a city, I guess, could decide what topics to teach in their own schools. But I still think they're under the aegis of the Agency of Education. I don't think they can independently decide that. So I think that word education does not necessarily have to be in the list. And these are municipalities that only are cities or towns. Are there any GORs that, I mean, I know you're a GOR expert, so I didn't know whether they would be part of this or not.
no, the definition calls out incorporated cities and towns. So the GORs
Right.
would not be included,
Thank you.
nor the grants.
Senator
Well,
Clark.
Senator Rom. Oh, Senator Clarkson first, and then Senator Rom.
thank you. I had a couple of comments. A technical one, you said that the commission shall elect a chair, and yet the word you have on page, on page 6, line 11 is select a chair. I like the idea of selecting a chair. But anyway, that's just a technical, you asked for technical things. I agree with Brian. I had education as one of the questions on the list, and also revenues. The revenues of the state are a big issue, and it is having served on Ways and Means, we do not grant municipalities the opportunity to raise revenues of the state. I mean, in very specific situations, we grant them the opportunity to have a local option tax, and that's it, other than fees.
So I'm going to go to Senator Rom first, and then, because then we'll get into these discussions, because I think that goes just beyond, a little bit beyond just a technical clarification here.
Oh, I'm sorry. Okay.
I just wanted,
I had those on the list. I had those two concerns: where are revenues and education.
Yeah. But I just, so Senator Rom, did you have a clarification question for
I think
Tucker?
it's a clarifying question. I was wondering if this applies to uniform codes, like streamline agreements we have with other states, interstate agreements with places like New York or Massachusetts or New Hampshire, or international agreements we have with Lake Champlain. What if someone, yeah, I'll leave it there.
There's no prohibition here from a proposal from a municipality that might deal with one of those subjects and that is not already prohibited by the exhaustive list in subsection C. But recall again that whatever proposals come in are reviewed first by the commission, and then the commission selects the proposals that get advanced to the General Assembly. And then you all get to have a substantive debate about whether to approve the proposals and admit municipalities. And because that is within your supreme legislative power, you have the red pen to strike out anything that might interfere with, for example, an interstate compact or the state's required participation in any of those compacts or agreements.
Okay. I'm not even saying I disagree, but what if one town on the border wanted to like do something with Canada, and they get it really creative? Or what if it was like a Lake Champlain related issue? How would other jurisdictions then know who rules are like.
we
feels
would approve.
complicated.
Yeah, and in
So
addition,
they have
there's
to come with their
Yeah.
package of changes. That's kind of like a charter change, isn't it?
Well, it is, except that
Okay.
it is, except that it's, anyway, I'm sorry that we have to go through this horrible, protracted process to give the towns any authority at all to make any decisions.
I hear you.
But just given the nature of the General Assembly, this is what we have to do. And I have to say, I think this, I have two things here. One technical thing is they can't even put stop signs on their town roads, on the town roads. That is ludicrous. But anyway, I have a huge problem with this humongous set of things that they're not allowed to do, because I think that that's, but people got all upset about it. And then the other thing I would do is I would drop the findings. As I remember, the findings caused a lot of consternation on the floor. People said, what do you mean the state laws prevent them from being creative? And as I remember, there was a lot of conversation about the findings itself, as opposed to the concept of allowing more self-governance. So I would just completely drop the findings. So, Senator Clarkson?
I'm not sure. I mean, I can see streamlining them, but I think it's very important to clarify why we're doing this and provide intent for people to understand, because I think most people don't have a clue about the restrictions at the moment that municipalities face in making decisions and in doing things on their own. I don't think they have a clue. So I think that actually, even for the General Assembly, I agree. Perhaps we would not want to do anything that begs more questions, but I think we should be very clear on our intent with what we're trying to accomplish in this bill.
I agree, but I think intent is different than findings. And we can put an intent in there without having all of those findings that talk about how we don't allow them to do anything and how it curbs their creativity. And that brought on a lot of discussion last year,
Right.
as I remember. And I think it's our responsibility to let the General Assembly know. Anyway, we can leave them in there if we want, but we definitely should streamline them and make them not controversial isn't the word I'm looking for, but a lightning. Sometimes, as Peg Flory used to say, she had seen bills actually die because of fights over the findings as opposed to the content of the bill itself. So, and I've seen that too. Senator Collmore?
I agree with you, Madam Chair. I think there are 4 findings. The first 2 are negative, and I don't see any need to be negative. It says that, we inhibit or delay the ability and we limit the ability. And
Right.
I would like to see a phrase like, it will allow the municipalities to be nimble in terms of trying to figure out on their own how to solve problems which only affect them.
Yes.
I think if you're you turn it and you're positive, people will read it and say, "Oh yeah, that sounds good."
I think that's an excellent point. They all need to be flipped, and it needs to be more intent driven. Clarify what our objective is with it, and make it positive. This is what it enables. Yeah, but I absolutely agree. That's part of the problem I think Jeanette's having with the findings.
Senator Collmore and then Senator Rahm. I mean, Felina,
Okay, we spend a lot of time together, so it's easy to confuse us.
And you're right on top of each other right now on my screen.
I'm gonna ask sort of a rhetorical question. I obviously support this. I supported it last year. I support it this year. But I must admit, revisiting that list of all the things you can't do makes me wonder, and maybe I'll ask Gwen or Karen, I mean, what else is there left to do? I mean, if you don't have an answer, that's okay, but it's just sort of bothering me that like we've limited it so much. I mean,
Yeah, I think it bothers us too, but it became, the way I described it, it became a bit of a Christmas tree where we were decorating with all the different ornaments of interested parties that were concerned about their own individual needs. And I think what everyone was missing in the larger conversation is that there is no exhaustive list like this that exists for charters. They can do all these things in charters. That doesn't mean it's going to get approved by the legislature. You're just artificially taking up a whole bunch of things preemptively. And so I think that's our biggest problem with it, is that there wasn't that, I don't think that message was conveyed, that, you know, not only are we going through the charter process, we're actually adding an extra layer onto the process. And then on top of that, we're adding a list of things you can't do. So it's definitely like a neutered version of what we would want. But I think it got lost in the messaging. So this looks very different from what we had proposed initially. And it's definitely not ideal. And I would agree that, you know, the idea of this is to basically create sort of a living charter, because right now the biggest problem is that, you know, you have things that are written in law, whether it's general statutory law or a charter, that never get revisited. No one sees how they work. No one figures out if there are barriers to break down and kind of work things together, whether, you know, functions can work better between even just like committees that are established in a town, something really simple like that, so like a cemetery committee or a library, whatever. I mean, it could be anything. And so this would be an idea to just get it rolling. And then if it's successful, then building off of that and seeing, wait a second, if we're not so prescriptive in general law or charter law, and it's, the world didn't fall apart, maybe it's not so bad to just hand the reins over to truly local things. So we share your concerns.
yeah, I didn't bring that up to derail things. It just was bothering me. So
I would cross them all off if it were up to me. Senator Rahm?
I think I'm more in that direction too. I was just curious historically in the committee, if there was a conversation, instead of saying what you can't do, being clear about the areas where you can, and which I think are where it doesn't conflict with state or federal law, or maybe some, I might add like some kind of interstate compacts and international agreements. But, you know, everything I can think of that communities have wanted to do is somewhere on this list, you know, that seemed like the experimental way to give towns the ability to be laboratories of, you know, so I would say, I would just limit what they can't do, or say in these broad categories, this is where you can experiment.
Can I just say something there?
Yeah.
I think that we explored that, and I don't know if what happened in committee or out of committee, but you kind of get to the same result, because you say, oh, we want to deal with local issues. And then you say, well, what does that really mean? You're like, well, you know, it could be zoning, it could be roads. And then when you bring in that, and you're like, well, you can't touch this regional aspect of things, or you can't touch the state roads. And then, you're still, even when you bring up a topic, for example, like, you know, oh, just like liquor license fees that have been set in statute forever and no one's changing. And then they're like, well, we don't want you to do anything else other than that. So we have really specific carve outs. So I think we wanted to do it that way. It makes way more sense to do it that way, but it still kind of got to the same result, you know, like you were still adding things to the list.
Well, I think what happened is that it started out, and I would actually like to have us look at what that section was when we started it, before all the lobbyists got in here. The banking lobbyists came in and said, well, you can't have the towns doing their own banking laws. That isn't right. So then we put banking in there. And then you had, well, you can't have towns deciding their own environmental laws. I mean, it just got nuts. And I would like to see us go back to those broader and see where we get with that. See if we can. The people, my guess is that the people who voted against it on the floor last year are the same people who are going to vote against it this year, whether it's got 43 prohibitions or 3. They're going to vote against it. So, I mean, and it is so insane the way I can't, I mean, I just was when I was going through our elections through Title VII. Well, a town can have 3 select board members, but if they vote, they could have 5, but they certainly couldn't ever have 4 or 6 or 7, because we know that they're not smart enough to figure out how many select board members they need. Just drives me nuts. Anyway, Senator Clarkson and then Karen. Did you have a question?
I was laughing in appreciation of you.
So Karen.
So yeah, I think there was a definite evolution in terms of the list of what you can't do. And there a couple of things sort of strike us this year. There are 2 towns that have proposed charter changes that say that if any provision has been adopted in any municipality, that town, Winooski is one and Williston's the other, that town can adopt it in their community because it's sort of already been proven in another community. And when we first started talking about this whole concept, it was more along those lines, you know, and that would actually also relieve a lot of make work for the legislature. So anyway, that's a different kind of approach.
So can we go back to some kind of language like that, that if we've already approved, the legislature has already approved something in a charter change for one town, then any town, well, that's a whole different thing. That doesn't have to be part of the pilot. That could be any
Right.
town could have that, if we've maybe instead we should have a piece of legislation that says that if we have approved a charter change in any town, that then goes into the general statutes to allow any town to do that, with or without a charter. It becomes what do we call it? We have towns with charters that are ruled by charters, and then we have towns that don't have charters that are ruled by the general statutes. So if we've approved it in a charter, then it automatically becomes part of the statutes that any town can. Am I saying that right?
Well, it becomes
Okay.
possible for all towns.
Yeah.
So
Right.
may I read you the language of the charter change proposal from Williston, for instance? It says that any charter change approved for any other municipality may be adopted by majority vote of the electorate as a charter provision in the town of Williston without the need to return to the General Assembly for approval, provided notice is given to the Secretary of State within 30 days of the vote to approve the amendment. So you still have to get it through your electorate.
And that's a little bit different than because what I was thinking here was that it isn't a charter change so
Right.
Putney doesn't have a charter. But if the town of Brattleboro has decided that if we've approved a charter change for Brattleboro to do whatever, to put up a stop sign or to have representative town meeting or whatever, and it becomes part of the general statutes, so that now Putney can do exactly the same thing because it's part of the general statutes. Because if we're approving it for a town with a charter, why would we not just make it general law that any town could do that same thing?
I'm sure
am I
that's a
making
good
any
reason.
sense?
Sure.
I can think of a couple things though that you get pushback on. Gun
Like-
laws,
No,
elections.
gun laws and elections.
We haven't
they're-
yet passed that charter change.
Right.
Yeah, but I think, in other words, if a community, I know Montpelier voted to allow Is it 16-year-olds to vote in local elections?
No,
Brattleboro.
non-citizens.
Non-citizens.
Brattleboro has 16-year-olds.
So if they had gotten that approved as a charter, then Burlington could do that. Is that what you're saying?
Yeah.
What I'm saying is, yes, if
Yeah.
if we think it's good enough for Montpelier or good enough for Burlington, why isn't it good enough for Putney and Grafton?
Right. What's good for the goose is good for the gander.
If we don't think it's good for anybody, then we wouldn't approve it in the charter change.
Well,
Okay.
No.
I guess I'm just,
I'm not so sure. I think some things are very specific to certain communities.
What would
other
that-
communities may not have that same need.
I
But they
can't
don't
think
need
of
to adopt it.
anything. I can't think of anything that if it's good enough for Burlington or good enough for Montpelier, it isn't good enough for Putney.
And they would proactively have to adopt it, but it's there as
Well,
a
yeah.
possibility.
And I think sometimes even within the larger communities, there's a differentiation between like the downtown district and the rest of the municipality. You know, you like, let's say you allowed people to drink openly on Church Street. That would probably be very specific to Church Street, like it is Bourbon Street, but not all of Burlington. So how you
Well-
might do that somewhere else would be challenging.
But that I don't think is in their charter, isn't it? Those are ordinances.
I don't know. I mean, we let a lot of people do that, right? Like walk away with to-go cups right now.
Well,
but
during the
I don't-
pandemic, we're
Yeah.
letting almost everybody do that.
I don't think that those that Burlington probably has in their charter that they can drink on Church Street. I think my guess is that that's an ordinance, not
Yeah, it
not
sounds
in
like
there.
That's Title VII. Title VII allows outdoor consumption permits for first and third class licensees in designated locations. And Burlington's charter may have something more specific that deals with outside consumption. And Title VII actually does not allow curbside pickup or delivery of alcoholic beverages from first and third class licensees, but it is happening. So
it's happening because of the emergency order.
Yes, but so go back to my contention here. If Burlington, if Title VII allows that, and Burlington has in its, whether it's an ordinance or whatever, that it can happen on Church Street, but it can't happen on Pearl Street. I don't know what. Why wouldn't it be allowed to happen in Putney on Main Street, but not on River Road? I mean, if I cannot think of one single charter change or one single thing that would apply so specifically to one community.
How about cannabis sales? I mean, we're now in the middle of all these towns taking a vote on whether,
Yep.
I mean, to me, that was a mistake in the first place to have an opt-in rather than opt-out. I know Gwen, we will disagree on this, but then the same would be true for that.
Yes, well, but that's not a charter change. That's not a
Oh, right.
charter. That is, they have the
Right.
right to vote one way or the other, and we're giving them that right. But what I'm saying is that if anything has been approved in any charter for any town, it ought to go into the general statutes to be allowed in any town.
And the town would have to pass it, one assumes. I mean, the town may not want it,
Of course.
but it's available to the town if they so choose.
Yeah. Tucker, I'm sorry. I got this really derailed, but I'm just so.
The different formulations of this are all really interesting, and they all trigger different constitutional analyses under the Vermont Constitution. The first formulation that would allow a chartered municipality to amend unilaterally their charter so long as powers were granted in another municipality's charter might be unconstitutional because they would be amending statute, which is your exclusive power. They can't do that. It would still have to come to you, and allowing them to amend their own charter would be an unconstitutional delegation of your legislative authority. Senator White's proposal is interesting because you are all in the driver's seat for general municipal authority. So if you want to, with any charter that comes up this session, in future sessions, if you see a power that you determine should be a general municipal power, you can add it to the police powers listed in Title 24 in Section 2291, wherever you want to couch it, and you can grant it broadly to any municipality in the state. There's also really interesting constitutional analysis that will have to happen with some of these charter proposals around if powers are granted retrospectively. If the General Assembly says, Williston, you get to have powers that we have already granted as of the effective date of this bill to any other municipality, you've incorporated by reference all of those other statutes into that statute, and that might be constitutional. But then you are not binding future assemblies. So if a future assembly says, City of Montpelier, you specifically get this charter power, it's not entirely clear whether that future power, which is specific and later enacted, would be accessible by a community that has a past authority to adopt any of the powers that have been granted through charter. And you start to get into this area of conflict between, are you actually granting special authority or are you granting general authority? And what is the intent of that future assembly when they pass the statute? And it becomes increasingly problematic for chartered communities. It would ultimately be detrimental to those that have their powers in statute if you had some sort of formula where chartered powers were available to any municipality, because the chartered municipalities would be in a position of, well, we have specific state law that defines our powers. If there's any conflict there, we're going to have to amend our charter, go through the process, and go back to the General Assembly. So there's a lot to unpack there that, at least for me, is really fun and interesting. And I hope it is for all of you too.
Yes, it is very exciting. So
You must be really a lot of fun at parties, Tucker.
So, so I guess we should at least try to go back to the pilot project and maybe reduce the change the findings and reduce the number of prohibited areas. And I would actually, I think that it's very interesting that if we saw something coming through in a charter, that we could, I think you're saying, Tucker, is just, and it seemed like something that any town ought to be able to avail itself of. We could just approve that charter, but we could also amend the general statutes to allow that particular thing without this kind of overbroad thing that I was thinking of. And that would be very interesting, because it might, I mean, it took us 4 years to allow towns to have their, what was it? Their
town clerks to be appointed. It took more than that.
Yes. Oh
Way
my
more than
gosh.
that.
No, that one.
Parking meter money, parking
Parking
meter
meter
money.
money. Oh my God.
Parking meter.
So anyway,
That's right.
maybe we can do,
Yeah.
these are separate things, but maybe we can do them both as we see charter changes coming that we want to actually change the general statute. Senator Colmer.
Thank you, Madam Chair. So as you were talking, I had fun. I went back to look at the roll call vote on S-106 last year. It was 21-8. And it's really interesting if you look at who voted no.
Yeah.
To me, no discernible pattern.
So who voted no?
because we're on YouTube. Oh, of course, it's all public records. Who cares?
Yeah.
So for instance, Senator Baruth voted no. Senator Brock voted no. Senator Hardy voted no. Senator McDonald voted no. Senator McNeil of Rutland voted no. So it was kind of like all over the place, and but it did pass. So I don't know that we want to change too much of it. You know what I mean? In other words, not that we have an absolute certainty that we can get it done twice, but I think we can.
I think you're right. I think you're right. I'll keep my idea for another day. I still want to pursue it, but
well, we will have
but
this
I would
opportunity after crossover, because we'll have some charter changes
Yeah.
and we can decide if we want to adopt them for everyone else.
I would like us to look at the are we running over our time here? No.
No, the next event's at 3:30.
Okay. I would like us to look at the original, what was originally in our bill around the parameters, and then where we ended up.
Tucker has sent that to us, by the way, by email.
Okay. Okay.
But before we leave, I know we're going to revisit this list, but I think we should be clear about what is specifically a state power, like revenue, like setting revenue and stuff. I mean, those are specific to we would not be able to, I don't think, grant a more liberal view on those. Like, you're not going to allow, I can't imagine we would allow a toll booth in Rutland.
Well, that doesn't affect just within their boundaries. That would affect people coming in from another municipality, and that isn't allowed.
Oh, right, of course. Okay. Well, but every town is not an island on their own. I mean, every town has people visiting it, and whatever is in that town affects anybody who comes to it.
But yes, of course. But if you, and a stop sign on a town road is going to affect people that are driving through, but it is within their municipality, and it is designed to impact their locality, their municipality.
Right.
I mean, we have state laws that are different than New York and New Hampshire. But and people from New York come here and
the other thing I wondered about is, with the extensive list of what you can't do, what's the point of having the 12-member commission? They don't have anything to do because everything's prohibited anyway. So let's not bother meeting.
Except revenue. Yeah. Right.
No,
yeah, we got to give them something to do.
Yeah, I would like us to look at these and to see why they really are. If it says you can't do anything against the US Constitution, the Vermont Constitution, or state law, that already covers these things. If there's a state law that says that you can't dump your raw sewage into the Connecticut River, that's a state law. Putney isn't going to be able to say we're going to dump our sewage in the river. Gwen?
Thank you for bringing that up, Chairwoman. I think that is getting lost in a lot of this. So I think our proposal would be just get rid of that enumerated list and really message it a little bit differently than we did 2 years ago when it was going through the chamber, and saying, we're essentially creating a charter process with actually more review. So it's actually more onerous to go through this process than the charter process. And you're already going to have eyes on it. And I think that already, even when my towns and cities contact, our, VLCT about charter changes, it's almost like their first step is like, what will the legislature approve? Once they figure out where the temperature is, or the barometer, or however you want to qualify it, that's where they start the conversation. So I don't see any community going through this heavy lift of putting all of this together as a community and putting ideas out there that they know instinctively are going to get shot down. So I think that you have to trust the process, not only for what you're reserving as your right as a General Assembly, but and obviously the Constitution was automatically there as a stopgate, but also trusting that the communities are going to be smart enough to understand that if they're going to ask for crazy things, they're going to get shot down, and there won't be a recommendation from the commission to the legislature to say, hey, this is a good idea. And so I think that needs to be the bigger message, rather than this Christmas tree of ornaments that you're hanging, that you're never going to cover everything. And by the time you get to the end, they'll have nothing left.
Karen?
Yeah, just following up on that, another sort of fallback conversation that we had over the last year was maybe just setting up the Self-Governance Commission and letting those conversations happen outside of the State House. And so towns would have that conversation with the Self-Governance Commission. And then if anything came of it, the commission would, come to the legislature or the town would come to the legislature with the backing of the commission, right? There would be somebody that was sort of apolitical, local, state, apolitical, that could support them in whatever the proposal was.
So before we wrap this up today, what I think we should do is look at kind of two options here. One is to go back to the original under 5805, I think it is, C, and the original language there. And the second is to Karen's suggestion, which I think what you were saying was to just set up the commission and don't address these issues at all right now. Let the commission work with the towns around that.
Yeah, around what they think would be appropriate local measures. And just start the conversation, basically.
Right. Without setting up pilots, you mean, and let the commission come back to us and say, you know what, we think it would be great to have pilots because we have this need. These are some of the needs that have cropped up and we'd love to have a pilot.
Right. Or have the town come back to you and say, we'd really like to put these measures in place. And the commission, which has reviewed them, thinks this might be a good idea. But the decision is all still yours. It might just take the conversation out of what in the House seems to be a kind of toxic environment.
I know.
Well, but the composition of the House is so radically changed. I mean, if you look at that GovOps committee, it's a pretty different crowd.
And I wouldn't necessarily think that translated into more support for this idea. I don't know that for a fact, but because if you look at, like Brian just said, if you look at who voted against this, it was
inexplicable.
Mm-hmm.
I mean, at least on face value, right?
So anyway, so let's talk about those two options next week and have some of the rewrites of the findings, take out the toxic ones and just have
well, flip it,
because
make it more positive.
Yeah, that is exactly what the two that Brian was referring to are what generated a ton of conversation on the floor last year, as I remember it. Okay.
On that last piece, could I ask you all to send some of your proposals for the findings and intent, since they are your findings, which is my typical ask of all of you, is to frame them as you have found the issue and express your intent, and I'll put it in for you.
Will do. I can take a stab at writing some of those and sending them to the committee, and then we can get committee input.
I think that is what Brian and I had in mind. Yeah, intent and positive.
Great. Thank you.
Thank you very much.
Madam Chair, speaking of sitting on one
So
tuchus.
Okay, yes, but before Karen and Gwen go, I just want to remind you of what the Constitution says about this. It says no charter and corporation shall be granted except for each municipal, charitable, education, penal, or reformatory corporations as are to be and remain under the patronage or control of the state. That old Ethan Allen, he didn't
Well, and
like
how
those
that-
towns.
And how that's been interpreted ever since has been very interesting. So,
Yes, it has been.
especially as it applies to schools and education and towns and cities, for example.
We are definitely not a live free or die state. Manage free or you're definitely not.
Yes, we can have a 5-minute break.
Great. Thank you.